Hello. I would like to welcome everybody to uh, the contracts installment of the Race and the Law series. We have two terrific guests with us. We have maybe what I'll do is I'll first make an introductory remark about what the series is about, and then I'll talk about the panelists that we have. Um, Legal education, like the law, you might say, is inherently conservative. It is based on historical developments. It's based on old case law. And that has a lot of merits to it, but one demerit is that sometimes it does not adjust quickly to address the issues of the time. And there's a sense that we on the faculty and the administration have that it's important to supplement the traditional cogs of legal education, in particular important to supplement and complement the 1L curriculum. And that's why Daryl Miller and the Dean's Office has sponsored this series on 1L topics and race and the law. We are talking about the contracts installment of that series, and we have two terrific guests with us. Emily Hugh is the Gustavus Henry Wald Professor and the co-director of the Nathaniel Jones Center for Race, Gender, and Social Justice at the University of Cincinnati College of Law. She is a scholar and teacher of contracts, commercial law, and critical race theory since 2003, and she is the two-time winner of the Goldman Prize for Teaching Excellence. She is the author, a co-author of the forthcoming book, the Oxford University Press Handbook on Race and the Law in the United States, which should come out this coming year. And we have Duke's own Nikita Catino. She is a visiting assistant professor here and a 2012 graduate. She entered academia after a Sixth Circuit clerkship and 5 years of practice as a corporate associate with Simpson, Thacher, and Bartlett, where she specialized in complex debt financings. At Duke, she teaches a seminar in fintech and financial inclusion and researches the role of innovation in law and facilitating more equitable financial marketplaces. We've asked the two of them to talk specifically about their research and more generally about the topic, about how topics of issues of race and racial justice intersects with contract law and the teaching of contract law and the development of contract doctrine. The two of them will have opening remarks for about 10 to 15 minutes. They might then respond to each other. I'll serve as moderator. I'll tee up a couple questions, but I'm more interested in making sure that any questions that you have are part of this discussion. This is intentionally supposed to be interactive and participatory. So ask your questions in the Q&A and we'll get to them during the discussion. So Emily, Nikita, thank you very much for joining us. And Emily, let's start with you.
Hi, can everybody hear me? Oh, okay, great. So I first want to, it's really a pleasure to be here, and I want to thank Professor Richmond for moderating and Professor Ward for reaching out to me about this, and especially to my friend and former Cincinnati law colleague, Daryl Miller, for organizing this series and extending the invitation. I don't know if he's here, but if you see this later, hi, Daryl. And I also want to say hi to my friend and former law school classmate, Guy Charles, who teaches here at Duke as well, and he's an old friend. Also, thanks to everyone who's here. Thanks for letting my CRT students be here, and to all the staff for making all of this happen. So I've been teaching contracts to first years and also some form of critical race theory or race and the law to upper level students since the year 2000 when I started law teaching. I've also written about how contract law intersects and interacts with race, gender, sex, and class identities. As such, I spend a lot of time thinking about the socio-legal construction of race and identity categories and the role, if any, that contract law plays in that construction, and even more broadly in what one could arguably call the racial project that is American law and American legal education. A lot of people think, some people think it's weird to teach and write in both contracts and critical race theory. But I think I'm actually very lucky to have fallen into and taken up this work, not only because it sits in a sort of sparsely populated and wide open space between private law and critical theory, which usually is applied more to sort of public law subjects, but also because it requires one to think pretty deeply about how contracts is taught in American law schools. And there's such a huge pedagogical value in sort of thinking deeply about this and consistently. So for the most part, the first year contracts course, as it is traditionally taught, I think elides how contract law and theory have operated to maintain and even create social inequality and hierarchy, despite or even maybe because of the pervasive mantra of freedom of contract, which I think Professor Catino is going to be talking about a little later. Um, and this is the case not only with regard to the teaching and study of contracts, but also to the teaching and study of other aspects of basic first year law courses like property, business, or not first year, core courses like property, business organizations, and even my very beloved UCC commercial law courses. Um, I have found, however, that the biggest barrier to effectively teaching about the constitutive nature of race and contract law in the first year is not necessarily finding ways of doing it, finding entry points for this, but rather it is the staggering amount of required material that we need to cover, often in only one semester. So at Cincinnati, we teach contracts as a 4-credit course in the first semester of law school, and I know that it's taught in other ways at other schools, but we've just got one semester. Another barrier which applies, I think, much more strongly to junior faculty who are on the tenure track, as well as contingent faculty. So this barrier applies much more to them than to senior faculty like myself, is the backlash that one invariably and inevitably receives, at least in the predominantly white institutions at which I've taught, when they attempt to bring issues of race or gender or sex into the core classes. Um, so over the past year in particular, and actually the past 4 years, and you could even say the past 20 years, I've been thinking about how I can more effectively teach contracts, not just as one of the pillars of American Common and Code-Based Law, UCC, but as what French philosopher Louis Althusser called an ideological state apparatus, an ISA, that is an institutionalized transmitter of of classical liberal ideology, colorblind ideology, and neoliberal ideology, which seem to have played a rather large role in getting us, and I mean the country, where we're at now, to this present and very difficult point in our history. Okay, so the question though is, how do you do this, right? How do you do this and cover doctrine, lots of doctrine that the students need to know to pass the bar? How do you do this and the things I've been talking about at the same time? Well, I think ultimately what it requires is a certain kind of drilling down into the cases in your casebook in order to find entry points where you can at least suggest to students or each other how contract law and doctrine is made in part based on who the parties are, right? The party's social status vis-a-vis one another, their place in the social order, their place in the sort of marketplace. And this is true not only for teachers and faculty, but also for students, right? Students can also do this on their own. They can really drill down and get into the the cases to learn the doctrine while also trying to understand how that doctrine intersects with or might even depend on a certain kind of social order. And I know for many of you probably here, doing this actually might even sort of save your sanity, especially during that first year of law school. it certainly did mine. Now, there are some really obvious entry points in the contracts course for this type of work, and the most obvious of which is probably the equitable doctrine of unconscionability, though this may be the case mostly because of the famous case that is used to teach this doctrine in almost every American contracts casebook. So as you'll recall, unconscionability allows for a party who successfully asserts it to either avoid their contract obligations, rescind a contract they had entered into, or to void unconscionable provisions of a contract. Williams versus Walker Thomas is, of course, the famous case that I just referred to, and that most of you either have already or will read. And in it, District of Columbia Circuit Judge Skelly Wright applied unconscionability to void an add-on provision in a consumer installment sales contract for the sale of household items and furniture, the enforcement of which, upon default on payment, resulted in Walker Thomas's repossession of all the goods purchased by Ms. Orly Williams and Mr. and Mrs. William and Ruth Thorne, even though even the goods that Ms. Williams and the Thornes understood as having been paid off because they were purchased long ago. Now, the race of the African-American or Black appellants, Ms. Williams and the Thornes, is never mentioned in the case. You know, we dare not disturb the sort of facade of neutrality, but it is discussed in many casebook notes and by many contracts professors, including myself, to varying degrees. I've never done it very satisfactorily, though, to be honest with you, at least not in my opinion. So a few years ago, then, I was invited to rewrite Williams versus Walker Thomas for an anthology called Critical Race Judgments, in which different legal scholars were asked to rewrite famous opinions from a critical race perspective. And hopefully, fingers crossed, it will be out in the end soon, although the project started, I think, like 5 years ago. Doing that really forced me to be more thoughtful about how I teach this case and to attempt to better understand the work the case does to sustain a certain racial and economic order, a socioeconomic order, even as it provides relief to Ms. Williams and the Thornes. That is, the case can be read or understood as an example of how the employment and development of contract doctrine can simultaneously perpetuate and resist racial hierarchy, or as Riva Siegel might put it, it's an example of what we call preservation through transformation. Okay, so how do we unpack this? So just to refresh all your memories real quick, right? Williams versus Walker Thomas. In that case, Judge Wright established the viability of unconscionability as a contract offense at a time when its viability was in serious doubt. And to assert the defense, a party has to, generally speaking, establish two kinds of unconscionability: procedural unconscionability, and which goes to sort of absence of meaningful choice, and unfair and substantive unconscionability, which goes to unfair or oppressive terms that unreasonably favor one party. So to determine procedural unconscionability, courts look at the circumstances surrounding the contract formation, right, of the particular transaction. They consider things like gross inequality, of bargaining power, terms hidden in fine print, whether and why there's a lack of understanding of the terms, and whether there was a use of deceptive or high pressure sales tactics. And to determine substantive unconscionability, they look at sort of the terms themselves, right, and the outcomes that those terms provide. But to try to get at the submerged but important racial or racialized aspects of the case, I employed in my rewrite a method of analysis, or at least I tried, informed by certain key critical race insights and values. So for example, a central critical race tenet that I incorporated into the analysis section of the opinion is that context matters. And by context, I do not mean only the facts and circumstances surrounding the transaction, right? And that's a phrase that you'll often see in the cases, and you'll definitely see it in Article 2 of the UCC if you've studied that. Socioeconomic context also matters in how the law is framed and applied and understood. In order to provide something more than sort of a preservationist sort of justice, the universe of relevant facts have to be filtered through re-articulated common law rules that allow for more expansive interpretations and understanding of why those rules exist in the first place. So to that end, in the opinion, like Judge Skelly Wright, I remand the case, but my opinion includes explicit factors for this and other district or trial courts to consider in making determinations about unconscionability and also about related claims of misrepresentation and fraud. And this connects directly to the next thing I tried to do in my rewrite of the case. So the rewrite also attempts to address what to my mind is one of the most problematic aspects of American contract law and other law, which is the obsession that the courts have when it comes to applying these sort of fact-intensive equitable doctrines with the conduct of the individual parties, which often results in the total discounting of broader circumstances and possibly exploitative practices, right? And this sort of breaking away from only looking at the individual is also one of the sort of core insights of critical race theory. In the case of Williams versus Walker Thomas, this preoccupation is often exhibited by the students in class, right, who, based on my classroom experiences over the years, tend to discuss the justice or injustice of the case and of the contract overwhelmingly in terms of Ms. Williams's individual choices, her characteristics and conduct, her choice to purchase unnecessary household items while on public assistance with 7 children, her lack of formal education, her inability to understand complex terms, her failure to read the contract, even as it comes to holding that in which she prevails. But while the choices, characteristics, and conduct of lower income consumers like Orly Williams certainly matter, right? Though for more complex reasons than are often understood, I think. So too do the predatory lending practices and business choices of installment credit retailers, like the Walker Thomas Furniture Company in Washington, D.C., whose collective conduct in that part of DC played a major role in creating and sustaining the conditions of Black urban poverty in the mid-20th century in our nation's capital. By focusing in the rewrite on both the individual appellants and the appellees, that is Walker Thomas's practices that in turn help to create and maintain a kind of, well, not a kind of, material and racialized inequality, I was able, I think, to articulate the rules in a way that would require trial courts to develop facts about these conditions and their causes, rather than just facts primarily about the party's individual characteristics and all of the sort of stereotypical assumptions that attend to those. Having said all of the above, I'm at heart really not just a critical race person, but I'm also a contracts teacher and scholar. And as such, in rewriting Williams versus Walker Thomas, I chose to adhere to a degree to some of the paradigms of reasoning used most frequently, both by the courts adopting and applying contract doctrines, as well as by, contract scholars writing on these subjects. And I did this intentionally because I've come to believe that these sorts of interventions, right, interventions about how race interacts in these first year and core courses, can be best affected not only by sort of talking and writing theory about them, but they also require theoretically informed examination and adjustment to the sort of nuts and bolts, right, to the on the ground doctrine. Now, this is a really tall order, but it has been done before in a fashion by the legal realists when they conceived of and drafted the Uniform Commercial Code, right? Karl Llewellyn and Soy Menchikov were able to enact certain realist values by incorporating those values into various UCC provisions and by clearly setting out certain principles of construction and interpretation. And that's actually something I'm thinking about for maybe a next project. But but I won't get into it now. Um, so that's really the end of my formal comments. I mean, I hope that what I've talked about here opens some possibilities for students to start thinking about, or to think more deeply about, how race, gender, sex, all of these things um, are are a part of law, and not just sort of like additions to these subjects. Thanks.
Terrific. Thank you very much, Emily. Nikita, let's hear from you.
Awesome. I'm so excited to be here. Emily, that was an awesome presentation. I learned a lot, and I continue to learn a lot from you. Like, I've been inspired by your work. You've been doing this for quite some time. So is my video on? Okay, I think I'm all good now. So I appreciate what you do in this space, examining the intersectional analysis of, like, in contract law. So basically that is, sorry. So that said, also to the students, I wanted to say that I'm excited for a number of reasons, not least of which include that I vividly remember my introduction to law school, which was almost 12 years ago. It was an 8 a.m. contracts course with none other than Professor Barack Richmond. I sat front row, center, obsessively asked questions, went to office hours, dreamt, had nightmares of contract law, and was fascinated, absolutely fascinated with the area, but often frustrated that fairness was a taboo concept. Instead, efficiency, freedom of contract, the reasonable person, bargain for exchange, these were and remain concepts foundational to contract law, and seem to belie the social context under which many contracts are entered, and often in ways that disadvantage already marginalized persons. And so for my part today, I'll speak briefly about a Third Circuit case that illustrates how assumptions in just the very first stage of contract law analysis, is there a contract, may result in disparate harm to people of color, and might also facilitate exploitative conditions. I'll then briefly touch on how the tensions between contract law principles and the social realities really permeate my scholarship in the financial markets, which concern the effect of the financial marketplace and how it exacerbates or can be used to mitigate economic inequality. So first, the case. I'm going to talk a bit about Morales v. Sun Constructors, Inc., and which was a Third Circuit case, where the court considered whether an arbitration clause in an employment contract written in English was enforceable against a former employee, even though the employee only spoke Spanish and did not know the arbitration clause was included in the contract. Some of you may have read this case, but the decision turned on whether mutual assent, an agreement, or a metaphorical meeting of the minds as understood by the common law was established. Now, mutual assent cares not about the parties' subjective understanding or intent, but rather an objective manifestation of agreement that could reasonably be relied on by the other party. And often this is easily satisfied by a valid signature. A failure or an inability to read or a lack of understanding are alone not enough to undo a contract. Now, against this legal backdrop, let me share some of the facts of Morales. Morales is a Spanish-speaking welder who Sun Constructors sought to employ for an immediate, urgent start. He passed a written exam, attended a 2.5-hour orientation that explained the terms of employment, including the arbitration clause, and he signed a 13-page employment contract, 8 pages of which included the arbitration clause. And all of these were administered in English. Aware that Morales did not speak English, Sun Constructors instructed another new hire, who was bilingual, to explain to Morales what was being discussed in the orientation and to help him complete the employment contract. Now, the bilingual worker admitted to understanding, in his words, about 85% of English. He, however, did not explain in Spanish the portion of the contract or the orientation that included the arbitration clause. For his part, Morales did not ask questions about what he was signing and did not specifically ask about the arbitration clause. Almost a year later, Morales was terminated for allegedly violating safety standards, and he filed a suit for wrongful termination, which claims were covered by the arbitration clause. Now, the majority opinion finds that mutual assent was established. It notes that Morales does not claim fraud or that Sun Constructors misrepresented the agreement. It further notes that Sun did not try to hide the arbitration clause because it covered nearly half of the agreement. The court then asserted that the burden of understanding was on Morales, whether, for example, by asking the other new hire to translate the document word for word, or asking to take the agreement home to have it translated, or at the very least, asking for a copy of the agreement, none of which he did. The majority opinion thus pointedly states Morales, in essence, requests that this court create an exception to the objective theory of contract formation, where a party is ignorant of the language in which a contract is written. We decline to do so. In the absence of fraud, the fact that an offeree cannot read, write, speak, or understand the English language is immaterial to whether an English language agreement the offeree executes is enforceable. Now, the dissent, however, opined that the case was distinguishable from case law. While normally the burden of understanding was on Morales, as discussed by the majority, in the dissent's view, that burden was shifted to Sun when it volunteered to offer a translation, and that translation omitted the details of the arbitration clause. There was thus some misreading or misrepresentation by omission in the language as communicated to Morales. And in the dissent's view, it was not unreasonable for Morales to rely on that translation provided by the company. Accordingly, there was not mutual assent on the arbitration clause in the dissent's view. But there's so much here. Now, an objective assessment of mutual assent in many ways makes sense. Now, to preserve the integrity of contracts and effective marketplaces, people shouldn't be able to just say, I want out, I didn't understand, read, whenever they feel like it. And we are not, of course, mind readers. So it would be difficult or at least costly to assess if another party understands the contract terms. So it's arguably efficient to assume as reasonable that all parties have read, understood the agreement, placing the cost of true comprehension on the individuals, but preserving contracts and the marketplace more broadly. But in Morales, given the social context, the real question is whether reliance under the objective manifestation of assent, i.e. his signature, was actually reasonable in light of the company's admitted knowledge that Morales can neither read nor speak English. Also, the majority makes a lot of Morales's burden to understand, but why no burden on the more sophisticated party here, knowingly employing a non-English speaking worker with an English contract? Now, while the dissent does shift the burden to the company, it would do so only if the company had voluntarily served as the translator. Yet, Spanish is the second most spoken language in the US by more than 40 million Americans. Why isn't it more reasonable or arguably more efficient for commercial parties to offer contracts in Spanish rather than compelling individuals to seek external translation and bear the cost of potential misrepresentation? Also, what does the objective view make of the obvious disparities in bargaining power here? Morales did not write the contract. He might not have understood the arbitration clause, even if translated. It's a huge question of whether or not, as a general matter, employees seeking work will have the funds or time to seek external interpretations. And ultimately, how does this reality and bargaining power ultimately result in exploitation if the market was to rely exclusively on these principles of contract law? Now, it seems an employer would not only lack an incentive to provide contracts in Spanish, but also lack an incentive to assist with translations. This would make contracting for non-English speakers not only inherently disadvantaged, but more costly and more risky. And so this is one way in which, just at the outset, the question of whether or not we have a contract has assumptions that one might speculate is probably an assumption that this is an English contract, or at least generally people would understand this contract. Otherwise, the law really wouldn't make sense to me. But nonetheless, the underlying assumptions here disadvantage a large population in a way that legislators have to come on the back end to provide consumer protection laws, to require either certain disclosures in various languages, or certain translations. And so this is another way in which, when we examine contract law, looking at underlying assumptions about who has the duty, and who has the practical ability to understand, is really important and may exacerbate some harms or ultimately create some problematic scenarios in which an already disadvantaged person in the bargaining scenario is further disadvantaged. Now, my work, I often look at financial innovations to see if these new services are operating in a way that makes the marketplace more equitable. So for example, one project I have relates to earned wage access programs, which is set to be an innovation or a intended to displace payday lending. Really, much of the types of services is intended to place the types of fringe services that appear in Walker Thomas. And so in reviewing that marketplace and seeing the risk of that marketplace, much like the services that predate even the new technologies, we have the same issues of whether or not the parties, the concept, freedom of contract, whether or not they come to the table truly free, whether or not they actually have enough options to bargain effectively in any transaction in which they're entering, and whether or not what they're bargaining for, say these exploitative terms, interest rates, are, dare I say, fair, but really the result of a reasonable bargain, one that contract law assumes is effectively an even playing field, which in reality it is not. And so I'll just stop there and look forward to the Q&A, and thanks.
Outstanding, Nikita. Thank you so much. I have one question on the Q&A. I welcome others. Before we get to the list, let me start things off with one question. So the world of law, not just contracts, has this tension between text and context. You have a document, and then you're trying to figure out exactly what extrinsic elements that we should bring to the contract or bring to the document. We have this in constitutional law, we have it in statutory interpretation, and we certainly have it in many contracts cases. Whenever there's a piece of paper, we're always wondering what other elements we should bring to the adjudication that are outside the piece of paper. In the world of contracts, I think is especially interesting because when we open up, and both of you have spoken very eloquently and compellingly about the importance of context, the importance of of adding other perspectives to the dispute beyond what is on the written text. And I guess one question I have is what sorts of fields, not just what sorts of information, but what sorts of disciplines do we really want to incorporate and maybe even think about incorporating into legal education? Emily brought up the legal realists who were enthusiasts of the social sciences and contrasted that to, I guess, what both of you talked about, the inherent mantras or the inherent philosophies that are baked into legal jurisprudence. Freedom of contract, individual autonomy. So what else should we be studying? And should we be incorporating it into legal education? What sorts of inquiries should we really enshrine into standard contextual analysis? Emily and then Nikita.
Thanks. This is such a great question, and it's one that I've been thinking about a lot lately. And I made a reference in the end of my remarks about the UCC. And you know, lately, especially, I've been looking at the way in which the UCC does that, right? What did the drafters of the UCC say should be considered in terms of interpreting and understanding the contract or the transaction or the agreement? And, you know, for those of you who have taken art sales or, you know, any UCC class, you know that they really put a lot of value on things like course of performance, course of dealing, and usage of trade. And that throughout the UCC, within its provisions, you see this reference to, you know, these determinations need to be made based on all of the facts and circumstances surrounding the particular transaction, right? And then also in Article 1, in their sort of framing or principal provisions, they talk about liberal construction, about sort of animating the animating policies or goals of the UCC to sort of clarify, modernize, and make more efficient and fair, actually, commercial exchanges. And it occurred to me that I've been thinking, like, why can't we do a similar thing with regard to other kinds of things that should bear on how we interpret and understand what contracts mean to particular parties? Um, you know, uh, and through that, you could maybe bring in, you know, social science research, both sort of qualitative and quantitative empirical research, historical research, and urban, you know, I love, Nikita, what you said about, I love that you're thinking about sort of alternatives to and innovations in, for example, to replace fringe banking, right? The fringe economy. I've done a little bit of work in that area too. And so I think that's a place to start. And, you know, it's definitely doable. I'd have to think a lot more to kind of answer your question better, I guess, but that's kind of where I'd start.
Awesome. To add to that, I think about, and I'm also just curious what you guys think, but and my research, I incorporate a bit of like behavioral law and economics. I find that contract law is often rooted in law and economics, and I feel like at least behavioral law and economics, understanding the realities of human interactions, their assumptions going into transactions, what it does for someone to have, that even explains what poverty, how that impacts decision making and one's assessment of contractual terms and what the outcomes or the benefits, the trade-offs might be. And so infusing and who we deem our elusive reasonable person, some concepts of behavioral economics, law and econ might be useful. I'd also add, and I know it's like a burgeoning area, but law and political economy concepts and contracts really is at bottom trade-offs in power, whether it's, you know, wealth accumulation, the resources, and so understanding what those trade-offs mean in the sort of broader marketplace and how you know the assumptions underlying contracts might affect or might exacerbate disparities in power could be a useful analysis as well.
That's great. One question from the list, which I think emphasizes or builds off of that discussion. If there is a great importance on understanding context and in understanding particular cases and more broadly understanding the world in which contracts take place, then a diversity of views in the classroom and diversity of perspectives would obviously add to that understanding. Context is multi-perspective, and therefore more perspectives you can get in the classroom would help that pedagogical objective. But that sometimes also puts a burden on individual students. It particularly puts a burden on students from historically marginalized groups. And there is a very legitimate question: how can students, especially if there's a perception that the professor is less than enthusiastic about bringing in alternative perspectives, how can students and student allies refocus or maintain a focus on a critical theoretical point when the classroom environment might not always encourage engagement?
I can speak to that first. Is that okay, Nikita? Okay, so this is a great question, and it's one that I first encountered when I was a first year in law school, right? And you know what happened there was that there were two things that happened. First, for example, in my criminal law class, when rape was the topic that was coming up, several students got together to sort of strategize and organize a way to respond based on our varying sort of backgrounds in other areas, right? To formulate a strategy of how to respond if someone said something in our view, which was really crazy in class, and that almost always happens when you're talking about rape, right? And we knew that our professor wouldn't be able to sort of effectively do that. You know, and so you know, I learned a lot from particularly watching some of my classmates do this, and it did take the pressure off a lot of it did take the pressure off of us sort of individually, right? Because we knew that there were many of us in the classroom sort of strategizing to do this. The other thing that happened my first year was, and this is really, really important. There were these third years when I was a first year, and Guy was in my first year cohort, Guy Charles, your colleague. And these third years had formed this critical race theory reading group. And so every 2 or 3 weeks, we would get together at someone's house or apartment or whatever, and we'd have reading assignments and we would talk about it. And the third years would sort of mentor us in terms of like how to navigate this, right? And it was so important. It was so important. It's the way and where I found my people, my community, but also where I started to understand that there is another way of thinking about and articulating some of these concerns in class, even if your professor isn't trained in the part, you know, particularly to deal with it. And that was really remarkable. Now, I will say it's a lot of extra work. It's a lot of extra work, but if it's not happening in the classroom because the teacher doesn't have the sort of ability to facilitate that conversation, and a lot of professors don't, you know, then it's work that, you know, if you're willing to take it on, you know, it's really well worth it. And I really, really encourage allies to take that work on, because it's something that I know a lot of students of color and women and LGBTQ plus students have been doing, you know, for, you know, since we've been allowed into law schools. So, so that's my one answer.
That second part was largely going to be my answer, and that while it is more work, and unfortunately so, and so there is this inevitable tax here, Westlaw and looking at legal scholarship is amazing to help provide the language for what you're feeling or like what you intuitively think is right or wrong. And so while the professor might have one viewpoint, there are professors somewhere else that have written on a different viewpoint, and it might be the very viewpoint that you have, but you don't yet have the language to articulate it. And so doing a Westlaw search of secondary sources, law review articles in the area that you're learning, I mean, not just for this, but it's helpful just to have broader understanding as well. But with issues that you don't feel are effectively tackled, there very well may be scholarship dealing with it. So
great. One specific question to Nikita about the Morales case. Was the decision and this actually, I think, in a different way, but a very interesting way, is another take on our emphasis on context. Was the decision in Morales influenced fairly or unfairly by a different contextual factor? That is, the court's sense of whether arbitration clauses are basically good, or basically a good or fair idea. My understanding is that courts also have very stylized perspectives on arbitration as an institution. What's your take on that, Nikita?
That's a good question. So, I mean, in reading the case, there was an effort to ensure that there was mention that the arbitration clause, like arbitration clauses can't be invalidated. We should treat arbitration clauses the same way in which we treat broader contract provisions. And that, literally explicitly it quotes that arbitration clauses are enforceable to the same extent as other contracts. And so there wasn't necessarily a preference, and I'd be curious on what the broader context is, and that there might have been some push against arbitration clauses, and they're saying, hey, arbitration clauses are just as any other part or provision of this contract, and we're not going to treat them distinctly or uniquely. And so I can totally see that being the point, part of their point, to not distinguish the arbitration clause in the contract as being some unique clause that needed unique agreement to.
Can I jump in on this question?
Yeah, please go ahead.
Yeah. Okay, so right, Nikita, everything that you said. But I think also, one thing about so when arb clauses come up, when in my courses, when I teach them in the context of consumer contracts, right, where there's and especially in the UCC, in the sales course, and this whole issue of whether arb clauses are good or bad comes up a lot. And it really depends, right, on context. I mean, I think in a business to business context, it makes a lot of sense. It's much more efficient. It's in all ways, right? Less costly, takes less time, all of that. But for the consumer, right, from a consumer business transaction, it's, there is a difference in terms of how arbitration functions and how it may disadvantage the consumer vis-a-vis the business. So those kinds of things. And I know that, among contract scholars who work on these things, it's almost like, the contracts, most of the contracts people I circulate among, like, hate arb clauses in the context of consumer contracts, right? Dislike them intensely in the context of employment contracts, but the courts seem to be perfectly, they think it's great. And especially with, like the FAA and all of that kind of thing. So it's a really, I kind of hate to say it, but it again also comes down to sort of the context of the type of transaction you're looking at. But that's a very excellent question. A hard one to answer.
So, these questions are feeding as segues to one another. We are aware as lawyers that we look at things through the world of law and through the lens of litigation. And, the drafters of the UCC, as you said, Emily, explicitly wanted the law to fit the needs of business, not business to meet the feeds of law. Related to that, here's one question. Do you think the focus in the classroom, in the 1L curriculum, the focus on litigation, the focus on looking at the common law, instead of looking at contract writing or even informal enforcements and negotiations itself, do you think that focus on litigation limits the ability to analyze contracts through the lens of race? Or alternatively, actually, do you think that looking at these issues through the lens of litigation actually offers more opportunities to analyze contract law through the lens of race?
Yes. So I think that I think that the study only of appellate opinions mostly, there's some district court opinions and some, right, and occasionally, but is limiting on all fronts. Having said that, though, I have never taught contracts any other way, and I don't even know how I would begin to sort of incorporate sort of contract drafting into the contracts class. It doesn't, not to say it cannot be done or it shouldn't be done. It's just that I haven't done that work yet. But, I do think that it's important, reading contracts is really important. Um, just also to get a sense of how you interpret contract provisions, which is a huge part of the first year course anyway, right? So, so I definitely think that the whole pedagogy of legal education, which really focuses on, appellate opinions, is 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 kind of problematic and limiting across the board. But because we haven't done anything else, this is sort of a problem of inertia. Like I don't I don't have the answers for sort of how to do otherwise effectively. Um, I think we need to experiment more, and I think that our institutions need to give us as faculty a little bit more leeway, to sort of experiment in that way. But a lot of us don't have the wiggle room to do that, unfortunately.
I have a thought slash question because I hope to teach contracts, but I have thoughts on them because of the research. And one idea is that while we're sharing a contract, um, look at consumer complaints. One can look at a host of consumer complaints or even reports to, say, the CFPB. And then there'll be a sort of uh, a mass or some large number of complaints about a particular industry or a particular company and the way in which they do services. And so seeing that, because that's actually the ways in which I try to find the problem happening in the marketplace, one can look at a set of consumer complaints that haven't risen to the level of litigation, and then look at the contracts and then question, whether or not their issues rise to the level of litigation. If they don't, why not? Why did they enter into these contracts if they have these outcomes? And not only if they have these outcomes, what we do see online, others are reporting these potential risks. And so questioning how people enter into those contracts, you can get to that question without looking at just appellate cases. Also settlements. Sometimes courts are these issues are settled out of court. And so we can sort of speculate what the legal outcome might have been, but question why it went to litigation in the first place, I think is helpful to inspect the contract and the trade-offs there.
That's great. So we have time for one last question. And this is a question that I think isn't specific to contracts. It's across the educational experience, I think. How would you advise a student who is in a class where the professor is not just ill-equipped, but they may even have the requisite knowledge, but the professor is actively refusing or ignoring or dismissing student attempts to address issues regarding the legal rights and lived realities of marginalized peoples? Nikita, why don't you start, and then
Yeah,
Emily,
I
you
was
can
about to
finish this.
say, I mean, that's tough. How do you advise? I mean, I don't think I have a sort of an acceptable response here, other than that's unfortunate. And I've been there, and it's frustrating. And I mean, the way one can, I don't know, cope with that is in part to, like I said, find the resources that I think can either validate or give context or help you understand further their position vis-a-vis your position. Talk to other professors. Like I've gone to other professors about issue to see if I'm missing something or that professor that's taught it a certain way has missed it. And so that also helps. Go to office hours. Maybe they're not comfortable or whatever talking in front of the class about it, but interrogating that in office hours might help you get a more acceptable response from the professor. And ultimately, pass their test. Like this is their class. Sadly, you are in it for one semester. Get through it. don't sign up for another course. And that's my like honest response on that one. So
Yeah, that is a very hard question, and it's a question I get often, well, not often, regularly from my students. And it, so this is such a local question. This question really also depends on locality, you know, because it's very institution specific, with respect to whether there's a certain culture within your school, whether there's an administration that you think will or won't be responsive, whether your institution has, for example, a diversity, equity, and inclusion dean. You know, all of these kinds of things matter in terms of how you think about how to deal with that. But you know, I can't suggest a specific way, you know, thing that you should do in the classroom. But I think that in thinking through how to deal with it, you should take advantage of that as like a way of learning about how to strategize against, not against, but sort of to strategize when you have a barrier, a problem, right? That is, you know, maybe a barrier to your learning the doctrine so you can pass the test and pass the bar exam, right? And it's a very hard question because it requires a different kind of commitment, something different from just sort of like raising your hand and speaking out in class and opposing the professor. I think Nikita's suggestions are all excellent ones, but you know, in terms of like your mindset, and I don't know if that's what you know, if that's included in what the question is asking, but you know, you've got to approach, especially your first year classes, right? It's the study of law fundamentals. And so you approach the study, you know, right, if you approach how you study it to thinking about like socioeconomic inequality and hierarchies and all of those things, as sort of an intellectual matter, you can kind of cut through some of what I call that noise, that horrible, horrible noise. That, in my opinion, the biggest problem with this kind of scenario is that it can impede your learning, you know, because you're just so furious about sort of the way the professor's teaching. And if there's nothing you can do in the immediate context, which usually you can't because, you know, there's power differential in the classroom, then you've got to sort of deal with it in terms of your mindset and how you approach the subject, right? But that is so easy to say. It's very hard to do. I wish someone had told me that, though, when I started law school. It would have made things marginally better.
can I add one more small point? Become a law professor. Become the professor that you wanted, and you know, turn the curriculum on its head. And so yeah, that's a goal over here.
Well, that's great. Well, look, this conversation has illustrated exactly why Daryl was and the dean was so wise to have this series, and we're extraordinarily fortunate to have the two of you participate and lead these discussions. Thank you very, very much for not just being a part of the conversation, but really being so thoughtful. And thank you also. I will be the first to thank Nikita on behalf of our future students for leading this discussion and for bringing so much wisdom to their legal experience and their educational experience too. This, as I mentioned at the outset, is part of a series of discussions. The next discussion will be on February 23rd. That will be discussion race and the one-out curriculum, constitutional law. This will involve professors Matt Adler, Joseph Blokler, and Ernie Young, and a panel discussion with Christina Duffy Panza Kraus, the George Wellwood Murray Professor of Legal History at Columbia Law School. Nikita, Emily, thank you very much again. And thank you to everybody who took the time to participate and view this conversation.
Thank you.
Thank you.